siang Bapak Ibu, good afternoon. Assalamualaikum warahmatullahi wabarakatuh. Welcome to Indonesia Jentera School of Law, Sekolah Tinggi Hukum Indonesia Jentera. My name is Rizky Argama. Thank you for introduction, Pani. Who will be a moderator in today's lecture. We are very honored to have with us here today Professor Matthew Harding, Dean of Melbourne Law School at the University of Melbourne, as our speaker for today's lecture. Dean Harding will share his vast knowledge on the role of civil society in democracies, especially from the perspective of the Australia's common law experience. We are also very honored to have Professor Susi Dwi Haryanti, distinguished professor of Indonesia Jentera School of Law, as a discussant, who will deliver her perspectives on today's topic after we hear Dean Harding's lecture. I also would like to thank Professor Tim Lindsay for his support in making this lecture possible, and also welcome to all the Melbourne Law School alumni here and our invited guests who are joining with us here this afternoon. For those joining us virtually, you can engage in the discussion following the lecture by utilizing the Q&A menu on Zoom. Thank you for your participation both in person and online. And now I'm going to introduce our speaker today with you. Professor Matthew Harding is Dean of Melbourne Law School. Matthew is a leading academic expert on private law as well as the law of charities and not-for-profit organizations. He has published extensively on topics in not-for-profit law and regulation, the law of property, and judicial practice and precedent. He is the author of Charity Law and the Liberal State, published by Cambridge University Press 2014, which is a major monograph on the philosophical foundations of charity law. Matthew has been a visiting scholar at, among others, the University of Toronto, Queen's University Belfast, and the National University of Singapore. Matthew graduated from the University of Melbourne in 1998 with first-class honors degrees in law and in arts. He also holds a Bachelor of Civil Law degree with distinction and a Doctor of Philosophy from the University of Oxford. Before joining the Melbourne Law School in 2005, Matthew also worked as a solicitor in Melbourne. And now he teaches a range of subjects in private law, legal theory, and charity law at the Melbourne Law School, as well as supervised a number of PhD students. That was a very short bio about our speaker today. And now, Dean Harding, your time is about 30 minutes. Time is yours, please.
Thank you very much, Rizky, and thank you to all of the faculty and the community of Jentera Law School for hosting our visit today, and for inviting me to give this talk. So I want to talk to you today about civil society organizations that engage in political advocacy, and I want to offer a perspective on this topic that's informed by the common law tradition, and in particular, as you'll see, the activities of common law judges developing the law of charities in the common law world. So in common law countries, as is the case everywhere, civil society organizations are an important and influential part of the political landscape. They advocate on issues of the day. They engage in electoral politics. They critique government. They hold government to account in important ways. The extent to which civil society organizations may perform these various roles and also enjoy state support has long been contested in the common law world. And so in this lecture, I want to explore with you the common law approach to political advocacy on the part of civil society organisations. Now, as I said at the outset, this common law approach has been developed largely by judges deciding cases, adjudicating cases, going back hundreds of years, back to the 1600s in England. Very recently, this common law approach has also been adopted by legislatures. And we've seen legislatures enacting statutes that purport to regulate political advocacy on the part of civil society organisations. In the case of the judge-made law and also the legislation, the setting that I'm interested in here is the law that has been developed that articulates and then regulates organisations with charitable purposes. The key concept here is charitable purposes. I'll come back to that in a minute. In the lecture, I want to review 4 jurisdictions with which I'm familiar: England and Wales, my own country, Australia, Canada, and New Zealand. I want to argue that in none of these jurisdictions does the law fully reflect the competing values and principles that ought to inform the legal treatment of civil society organisations in a liberal democratic state. But first, I need to take a step back and say something about the general outlines of the law that articulates and regulates charitable purposes. It has long been a principle of the common law that an organisation can be recognised as a charity for legal purposes only if its dominant purpose is a charitable purpose that stands to generate public benefit. So that's a fundamental principle of the common law. Now, over hundreds of years, common law judges have developed case law that explains what is a charitable purpose and what is not, and also that sets out the considerations that need to be taken into account when applying the public benefit requirement of the law. As I said earlier, recently legislatures have further developed this law, enacting statutes that define charitable purposes and also giving legislative expression to a public benefit test. So charity is the key organising concept in this body of law, and organisations that are charities have a special legal status that civil society organisations that are not charities do not have. Now, why does this matter? It matters because charities typically enjoy state support that other civil society organisations don't enjoy. Tax privileges, in particular. Charities are exempt from paying income tax in common law countries. They attract a range of other tax benefits as well. Charities also typically enjoy a public trust and confidence that few other civil society organisations can access. And so for civil society organisations, charity status is highly desired and highly desirable. Okay, so that's the sort of context in which I want to talk to you today. Now, in that context, civil society organisations whose dominant purpose is to engage in political advocacy have not historically received favourable treatment. I'll give you some examples. In 1917, in a case called Bowman, Lord Parker in the UK House of Lords declared that a trust for the attainment of political objects was invalid according to the common law. And so a trust set up for the purpose of campaigning around some political issue, or campaigning for law reform, for example, such a trust under this rule would not be recognised as a valid legal trust. In 1948, again in the House of Lords, in a case called the anti-vivisection case, this dictum from Lord Parker was applied, and it was held that an organisation whose purpose was to campaign for law reform in respect of the use of animals for medical research, that this organisation was non-charitable because of its political campaigning. In 1980, Justice Slade of the English High Court of Justice held that the purposes of Amnesty International were non-charitable because Amnesty sought to procure changes in government policy in countries around the world where prisoners of conscience are held. So that's the historic common law approach. Civil society organisations with a dominant purpose of engaging in political advocacy have been viewed sceptically, and they have not been supported by extending to them charity status. Now, we should be clear, such organisations are not suppressed. They are free to carry out their work, but they may not carry out their work and also be counted as charities. And that's because of this rule against common law, this common law rule against political advocacy on the part of civil society organisations. So the question that naturally forms in the mind is, well, why would the common law take this approach? Traditional justifications for the rule against political advocacy have been weak at best. Let me take you to a couple of those. In the Bowman case that I referred to earlier, Lord Parker argued that judges are not in a position to work out whether political advocacy will be of public benefit. And of course, that's a key question in the common law approach to recognising civil society organisations as charities. And yet, in the common law world, judges are institutionally capable of making findings of fact about the public benefit of political advocacy. In the anti-vivisection case of 1948 that I just referred to, that is exactly what the House of Lords did. They weighed up the benefits and detriments associated with using animals in medical research, and then they concluded that there was insufficient evidence of public benefit on the facts of the case. So there the court showed that it was institutionally capable of handling the public benefit question. Well, another way of understanding what Lord Parker is saying in Bowman is to say that for constitutional reasons, judges should not make findings of public benefit about political advocacy, even if they are institutionally capable of doing so. On this view, the separation of powers demands that questions about the benefits and detriments associated with political reform are appropriately left to the legislature. But this view is open to challenge as well. A judge may find that a particular political reform will be of public benefit, but at the same time acknowledge that the achievement of the political reform is for the Parliament. And that's entirely consistent with the separation of powers. And indeed, the common law is full of examples of judges doing exactly this in a whole range of areas. So the traditional justifications for this rule against political advocacy are weak. And for that reason, it's not surprising that the rule has come under pressure in several jurisdictions recently. Now, notably, this does not include England and Wales, which is the jurisdiction in which the rule was first developed. In that jurisdiction, the rule continues to be applied. But in Australia, in Canada, and in New Zealand, the rule against political advocacy has been questioned in recent years. And so I'd now like to turn to those recent developments in those three countries. Let me start with Australia, which is my own country. In Australian common law, judges applied the rule against political advocacy following the English cases until 2010. In 2010, the High Court of Australia, our apex court, handed down its judgment in a case called AidWatch. AidWatch was an activist organisation, a civil society organisation, formed to agitate for changes to federal government policy in respect of foreign aid delivery in Australia. So it was an activist organisation campaigning for law reform. In finding AidWatch to be a charity of public benefit, the High Court of Australia adopted an entirely new approach to political advocacy on the part of civil society organisations. The court referred to Australia's federal constitution. That constitution establishes a system of representative and responsible government. In a series of landmark decisions delivered in the 1990s and the 2000s, the High Court found that our federal constitution implies a general freedom of political communication. The court reasoned in those cases that this implied freedom of political communication was necessary to the maintenance of the system of representative and responsible government for which the Constitution provides. Now, in AidWatch in 2010, the court went further and said that by recognising and protecting the implied freedom of political communication, Australian constitutional law also recognises that political communication generates public benefit. And the court said political communication generates public benefit irrespective of the content of the political communication in question. So on this approach, political advocacy is of public benefit because of the contribution that it makes to Australian constitutional culture. Thus, a civil society organisation whose dominant purpose is political advocacy may be a charity of public benefit, and it doesn't matter what the content of their campaigning is. They are of public benefit simply because they play their part in maintaining the system of representative and responsible government on which Australia's constitutional order depends. That approach to civil society advocacy is now reflected in Australia's Federal Charities Act of 2013. And in that act, political advocacy purposes are, within certain limits, recognised as charitable, but interestingly, party political purposes remain excluded as they were under the common law rule against political advocacy. So that's the Australian approach, a radical departure from the old rule. I'll turn now to Canada. In Canada, pressure has been placed on the rule against political advocacy in a different way. In that country, the rule has historically applied, and indeed it continues to apply. It was also supplemented and supported by provisions in Canada's Income Tax Act of 1985. Now, what these provisions did was that they restricted the proportion of income that a charity could spend each year on political advocacy work and can retain its charity status. So the effect of those legislative provisions was to restrict annual expenditure on political advocacy work to 10% of a charity's income. You could only spend 10% of your income on advocacy work. If you spent more, you would lose your status as a charity and the tax privileges that go with that. A charity called Canada Without Poverty challenged the constitutional validity of these legislative provisions. Canada Without Poverty argued that the provisions interfered with its exercise of its right to freedom of political expression under Canada's Charter of Rights and Freedoms. In the Ontario Superior Court of Justice, Justice E.M. Morgan agreed with that argument. He found that once the state recognises a civil society organisation as a charity, the state cannot then restrict that charity's freedom of political expression by limiting what the charity can spend on political advocacy under threat of losing its charity status. And so on constitutional grounds, those provisions of the Tax Act were struck down and no longer apply in Canadian law. Note that this approach applies only where the state recognises an organisation as a charity in the first place. Canada Without Poverty was recognised as a charity formed for the relief of poverty. It sought to engage in political advocacy as a way of furthering its charitable purpose. If Canada Without Poverty's dominant purpose had been to engage in political advocacy, then it wouldn't have been recognised as a charity in the first place, because the rule against political advocacy continues to apply in Canadian law. So in Canada, the rule has come under pressure. Provisions of the Tax Act that supported it have now been declared unconstitutional, but the rule continues to exist in the common law, and Canada, for that reason, hasn't gone as far as Australia. That brings me then to New Zealand. New Zealand is a country in which there have been many developments in this area in recent years, very interesting developments. Some of these developments were brought about as a result of a long-running litigation involving Greenpeace. New Zealand's Charities Registration Board, I think in about 2009, deregistered Greenpeace as a charity on the basis that the dominant purpose of Greenpeace was to engage in political advocacy. In that decision, the board applied the rule against political advocacy that existed in New Zealand law at that time. Greenpeace appealed against that decision, and the matter went all the way to the apex court in New Zealand, which is their Supreme Court. In a landmark judgment, the Supreme Court declared that the rule against political advocacy no longer had any place in New Zealand law. Instead, the court said, when a civil society organisation whose dominant purpose is political advocacy comes into view, a judge or a government official must apply the common law public benefit test. That person has to weigh up all the relevant benefits and detriments associated with the advocacy in question in determining whether to recognise the organisation as a charity. So the law was declared to be that. The case was then referred back to the board. The board once again said, well, the law has changed, but our view still is that Greenpeace is not a charity. It can't demonstrate public benefit associated with its advocacy. Greenpeace then appealed again. The matter went back to the New Zealand High Court of Justice. This is in 2020. The litigation went for over 10 years. Justice Mallon in the High Court of Justice finally determined the case by saying, no, Greenpeace is a charity of public benefit because political advocacy for environmental protection is of public benefit, and that is beyond dispute. Now, this question of what is indisputably of public benefit and what isn't has emerged as a central question for judges in New Zealand in the wake of Greenpeace. In 2020, New Zealand's Supreme Court had to rule in another case about a civil society organisation that engaged in political advocacy. Family First was the charity in question. This was a conservative Christian organisation that advocated for the traditional family in New Zealand law and policy. And to that end, The organisation engaged in public debates about a range of issues such as same-sex marriage, abortion, euthanasia, divorce. Family First argued that advocating for the traditional family was indisputably of public benefit to New Zealand society. So they tried to rely on Greenpeace. The Supreme Court disagreed. The Supreme Court pointed to the fact that reasonable people may have different views about the role of the traditional family in society. The court said that on some views, advocating for the traditional family might cause harm to certain groups, such as same-sex couples. Family First was found not to be a charity of public benefit. So Greenpeace and Family First show you two different applications of the same law. Then, a few weeks ago, the New Zealand Court of Appeal, the intermediate court in New Zealand, handed down judgment in yet another case. Here, a civil society organisation formed to advocate for the public provision of media, print, television, radio, and so forth in New Zealand, was advocating for something indisputably of public benefit, and the court found that that organisation was a charity as a result. So that's New Zealand, where the law has developed quickly, and there's some interesting questions in that, which I'll come back to. So now I'll move on to the concluding part of my lecture. I want to suggest two things. First, I want to suggest that recent developments in Australia, in Canada, and in New Zealand are heading in the right direction. Secondly, I want to argue, though, that no single jurisdiction has gone far enough to recognise in a coherent way the public benefit of political advocacy on the part of civil society organisations. So those are the 2 points I want to make. I want to come at those questions from a perspective that affirms the desirability of a liberal democratic state. So from that perspective, I think the rule against political advocacy is indefensible for reasons similar to those given by the High Court of Australia in AidWatch. A political culture in which civil society organisations contribute to public debates about law and policy is a culture that reflects and furthers liberal democratic values. Such a culture helps to ensure that government is responsive to citizens, that government is not acting corruptly, that government's not acting in the service of vested interests. Such a culture helps to ensure that citizens can disseminate, access, and evaluate information about the government so that they can hold the government to account. Indeed, I think there are reasons to think that political advocacy by civil society organisations might make an especially distinctive and important contribution to liberal democratic culture. Civil society organisations often speak for those, the poor, the disabled, refugees, children, religious minorities, and so forth, whose voices might not otherwise be heard or taken seriously in political circles. And government should be responsive to the needs and interests of these marginalised groups as much as it is to others. So that's the case for political advocacy on the part of civil society organisations from a liberal democratic standpoint. But we should also recognise that a liberal democratic culture cannot support all political advocacy because some political advocacy seeks to undermine liberal democratic values. So a civil society organisation that's formed for the purpose of overthrowing a democratically elected government or to advocate for the subordination of women in public life should not be recognised as a charity of public benefit. And similarly, liberal democratic values are likely to be undermined by hateful political expression, and there should be corresponding implications for the state's support of civil society organisations that engage in hate speech. Now, we should be clear that I'm talking about state support. there is a separate question as to when the state should tolerate political advocacy that is at odds with liberal democratic values. That question of toleration has to be answered, I think, on its own terms. But I think we can accept that there will be some kinds of political advocacy that a liberal democratic state should tolerate, but not actively support. And of course, when we're talking about recognising organisations as charities of public benefit, we're talking about active support. So I'm highlighting here circumstances in which the liberal democratic state has no reason to support advocacy that undermines the values underpinning that state. Now, I think this does help us to see some of the recent developments in New Zealand more clearly. For example, advocating for environmental protection, which is what Greenpeace was about, is consistent with the values underpinning liberal democracy. Advocating for the traditional family might not be. For example, where the advocacy seeks to withdraw civil rights from minority groups. I think it also helps us to see why the New Zealand Court of Appeal, in the very recent case of the Better Public Media Trust, recognised the promotion of public media as a charitable purpose of public benefit. There is a clear and direct relation between a robust, public-spirited journalism and democracy. So, one difficult question that arises once we start to think about political advocacy that undermines liberal democratic culture is this. How should we think about advocacy that is carried out in intemperate, confronting, emotive ways? Some years ago, when I first started writing on this topic, I took the view that the common law should welcome and support even political advocacy that is intemperate, emotive, confronting. A belligerent public protest about a sensitive, contested issue would be an example, or a social media campaign in inflammatory terms. My view at that time was that diverse means of expression are a sign of a healthy civil society in which different styles and modus operandi thrive. In recent years, I've come to question that view. And the worry that's caused me to rethink is seeing the way in which civil society organisations can engage in inflammatory public protest, social media activity that doesn't necessarily engender reasoned and thoughtful debate, but rather encourages opposing camps to solidify their positions. Now, again, I'm not talking necessarily about the question of toleration. The liberal democratic state may tolerate all of those forms of advocacy. But I now wonder whether those forms of advocacy should be supported and promoted in the same way as other forms of advocacy are. That's a topic on which I recognise people will reasonably disagree, and so maybe we can have a bit of a chat about that in the question time. Okay, so the developments that I've referred to in Australia, Canada and New Zealand, they're all heading in the right direction. In all three jurisdictions, those developments affirm the key role that civil society organisations play in liberal democratic culture. And in New Zealand, the developments recognise that not all civil society advocacy is going to be consistent with the maintenance of liberal democratic values. But I also want to suggest in finishing that no single jurisdiction goes far enough here. In other words, no jurisdiction at this moment in time has articulated a fully worked out and coherent account of how the common law should deal with political advocacy when working out whether a civil society organisation should be recognised and supported as a charity. Such an account should do three things. Number one, it should unequivocally depart from the old rule against political advocacy. To date, that has happened in Australia and New Zealand, but it hasn't yet happened in England and Wales, and it hasn't happened in Canada. Number two, such an approach should acknowledge the important contribution of civil society political advocacy to liberal democratic culture, irrespective of the content of what's being advocated for. To date, That has happened in Australia, but not yet in England and Wales or Canada. There are indications of it in New Zealand, but the Supreme Court in that jurisdiction has not yet made such an acknowledgement unequivocally. And then thirdly, a worked out and coherent approach would distinguish between political advocacy that is consistent with liberal democratic values and that which stands to undermine those values. To date, that is emerging in the New Zealand law, but not in the law of the other jurisdictions. So to end, philosophers have long recognised the critical importance to civil society, to the flourishing of liberal democratic polities and culture. But in the common law world, that recognition has only very recently been reflected in the common law approach to determining whether civil society organisations are charities of public benefit. That development is to be welcomed, but there remains a lot of work yet to do to work out a fully integrated account of the public benefit of civil society political advocacy. Recent developments do give us cause for hope. And can I end by simply saying that hope is greatly needed because the Liberal Democratic project is under increasing pressure and threat everywhere. Thank you very much.
Thank you, Dean Harding, for a very wonderful lecture. And now I would like to invite our discussant today, Professor Susi Dwi Haryanti, who will hear the situation of civil society in Indonesia democracy. I think it's quite different with what Dean Harding talked about the common law countries. Before that, let me introduce Professor Susi. Professor Susi Dwi Haryanti has been a lecturer at the Faculty of Law, Universitas Padjadjaran since 1993. She holds the position of Associate Member at the International Academy of Comparative Law and serves as a Senior Associate at the Center for Indonesian Law, Islam and Society at Melbourne Law School. Professor Susi completed her bachelor's degree from the Faculty of Law, Universitas Padjadjaran, with a specialization in constitutional law. She pursued her master's and doctoral degrees at Melbourne Law School, funded by the Australian Government Scholarship. Her area of expertise ranging from constitutional law, human rights law, to the comparative constitutional law. In 2023, Professor Susi has taken on the role of Distinguished Professor at Indonesia Jentera School of Law, alongside Professor Topo Santoso from Universitas Indonesia and Professor Sigit Rianto from Universitas Gadjah Mada. Professor Susi, also 30 minutes, time is yours, please.
Thank you. Good afternoon, all of. Pakai itu aja, bisa di broadcast aja. Yeah. Okay. Thank you, distinguished Professor Matthew Harding, distinguished Professor Tim Lindsay, and Pak Arif, and also all the participants of this afternoon public lecture. It is my great pleasure to deliver what is I call the penanggap, as a penanggap of Professor Matthew, a great public lecture. And I have to apologize that I have not yet prepared a very short paper in response to Professor Matthew Harding public lecture. So I have to bring my laptop here. I give the title of my presentation is Civil Society, Democracy and State, the Case of Indonesia, and a reply to Professor Matthew Harding. The role of civil society is well recognized for democracy, both in well-established democratic countries or emerging democratic countries, which are mostly regarded as a constructive, critical partners and participants. And since the 1990s, the global importance of civil society has increased substantially, and the scope of democratic action carried out by the civil society has constantly changing. And the changing concept of governance in 2000s lead to the three aspects of changing. The first one is the policy changing, the second is the institutional changing, and the third one is the relation between state and its people. And I took these three aspects of changing when I was doing my doctoral program in a Melbourne uni. As a result, that I read a book that consists of it. Actually, the book is a production or published as a result of a conference on governance that conducted in Australia, and it's resulted on the publication of 3 books. So according to the conference, the changing of the concept of governance leads to the 3 basic concepts, the changing of 3 basic concepts. The first one is the policy changing, the second one is the institutional changing, and the third one is the relation between state and its people. And what is the surprised me is that in terms of the institutional changing, according to the conference that published by the book, say that the most responsive institutional or state organ is a court, not a parliament. So in response to the changing of governance concept, the most responsive institutional state organ is a courts rather than the parliament. So it's make me surprised at the time when I read the book. And then in recent years, we know that shrinking democratic space that may lead to democracy backsliding and the increasing practice of populism and oligarchy in many parts of the globe also faced by many countries. And many NGOs or TSOs and then human rights institutions are being obstructed, criminalized, and persecuted. In Indonesia, although civil society enjoy protection and freedom in the immediate post-transition years and made remarkable progress, however, due to several factors such as competing political interests, then oligarchy, etc., and then their role and function is being challenged. And the situation might become deteriorated because of the upcoming general election in 2024. As Pak Arif previously mentioned, Indonesia is not in a good direction, in a right direction, or Indonesia sedang tidak baik-baik saja. So I think this is a very strong statement made by several leading public figures in Indonesia, including Mbak Bivitri and then Mbak Aswin. Most of them always argue that Indonesia sedang tidak baik-baik saja. And now I want to move. What is the importance of Professor Harding's public lecture, especially for me, because I already read your papers, very good papers, and I learned a lot from your paper. So in my opinion, the descriptive comparison of the common law practice dealing with civil society organization, in particular from England and Wales, then Australia, Canada, and New Zealand. So this comparison leads to several benefits, in my opinion. The first one is for educational purposes and pedagogical purposes. So from your paper, we learn a lot for the educational purposes, because I believe that even in Jentera, in many law school in Indonesia, we introduce the course on comparative law. either comparative law in general or a specific comparative law, such as comparative constitutional law, comparative administrative law, and etc. The second benefit of your presentation is that better understanding of legal system. So from Professor Harding presentation, we all know how the common law countries develop its concept on the what is the charity purpose, and then together using the general the public benefit test. I think that the practice demonstrated in England, then followed Canada, Australia, and New Zealand, show to us the different development of the development of the concept of charity purpose, that using the public benefit test, which is, I think, that's a bit complex here for us. That Indonesia is the trend or not, the kecenderungan. Indonesia is a continental legal system. Okay, so it is very interesting to study using a case or a court decision and how they develop a particular concept using a particular test. I think it is very important for law students in Indonesia. And the third importance of your public lecture is working on the legal data or the law that is in force. So when you explain about what is the judge opinion or what is the decision of the court of Canada, then New Zealand, as well as Australia, that using the legal data or the law that is in force. And it is very important for us to know how but the judges interpret the existing law. And again, in Indonesia, this is, we still have to develop and encourage our students to study about how to make a good interpretation of such a the existing law. And then the fourth importance of your public lecture is the suggestion of the lege ferenda. So how we have a lesson learned from the existing practice, then in order to develop a better law in the future, either in the form of a court decision or in the form of legislation or other regulation. And what is the lesson learned? So that's the importance of your public lecture. And what is the lesson learned of your public lecture? In my opinion, at least, there are 5 important lessons. The first one, as I mentioned before, is the development of civil society organization using charitable purposes with particular reference to political advocacy. Also, the more importantly, we also know about how court then use the public benefit test, which perhaps, please correct me if I'm make mistake, that maybe in some of the jurisdiction, the different jurisdiction, the courts perhaps develop their own when they implement the public benefit test, they consider about what is the social context or the political context. So the result perhaps took a different way. And then the second lesson learned is that in trying to provide about the charitable purposes and then political advocacy and also the use of public benefit, you use a different sources of law. This is a very important thing. So here I mentioned for the development, I directly quote your presentation. You say that, so the development to which I have referred in Australia, Canada, and New Zealand are heading in the right direction. In all three jurisdictions, those developments affirm the key role that civil society organizations play in liberal democratic culture. And in New Zealand, the development recognized that not all civil society advocacy is consistent with the maintenance of liberal democratic values. So this is what Professor Harding trying to say about the development of the concept. And then what is the use of different sources that I mentioned? It is very important for us in Indonesia. You say that it has long been a principle of the common law that an organization can be recognized as a charity for legal purposes only if its dominant purpose is charitable purposes that stands to general public benefit. Over hundreds of years, judges have developed case law that explain what is and is not a charitable purpose, and that sets out the consideration that inform inquiries into public benefit. So Professor Harding highlights the role of judges in developing such a concept. And further, he say that more recently, legislature have further developed this law by enacting statutes defining charitable purpose and giving legislative expression to the public benefit test, and much turn on whether an organization is a charity for legal purposes. And when you try to explain about the Australian experience, you say that in finding aid was to be a charity of public benefit, the High Court adopted an entirely new approach to political advocacy on the part of civil society organization. And you refer to the using of the Australian Federal Constitution and using a particular in a series of landmark decisions in the 1990s and 2000s, the High Court found that the Constitution implies a general freedom of political communication necessary to maintenance of that system, representative and responsible government. Again, this is important for law students in Indonesia. How to use, you know, that in relation to the authority or power, we know that from constitutional law perspective, there is the expressive power, then we have the implied power. So I think that in Indonesia, rarely law students are given a knowledge or a comprehensive knowledge how to find and how to interpret the implied power that regulated in the Constitution. So Professor Matthew, thank you for reminding us about the importance of the implied power of the Constitution, because it is very rare thought in law faculty in Indonesia. And then this is the second lesson learned, that is the role played by judges and legislature. And this is related to the main sources of law based on the different legal system. The common law system, as we know, judges and court through precedents, whereas the civil law system relies on legislation. Australia shows an interesting practice because, as you mentioned before, not only using the court decision, but also Australia tried very hard to develop a legislature in order to accommodate what the court say about the concept. And then the fourth lesson learned is the less political context. And I do understand why you put your focus on legal aspect. However, in the context of a fragile democratic country like in Indonesia, an analysis of political context is necessary. But I also found in your paper that you also touch the issue of a political culture. I found in some of the paragraph that perhaps at the end of your presentation, you said that a political culture in which social society organization contribute to the public debate about matters of law and policy is one that reflects and further liberal democratic value. Importantly, such a culture helps to ensure that government is responsive to the citizen and not acting corruptly or in the service of vested interests. It also helps to ensure that citizens can disseminate, then access and evaluate information about the government so as to hold the government to account. So, Professor Harding, even though that the political context is not quite deep discussed in his paper, but Professor Harding has touched the issue of the importance of political culture or political context in regard to the civil society and political advocacy. And this is the fifth lesson learned. That is the changing mind and hope. It is very interesting, in particular for me, because you said in recent years, I have changed my mind. In fact, I now think that the readiness of civil society organization to engage in inflammatory public protests and social media activity instead of recent argument and debate is one of the greatest threats to liberal democracy. And while it might be tolerated, it should not be supported and promoted in any political community organized along liberal democratic lines. There remains much heuristic work to be done to work out a fully integrated account the public benefit of civil society political advocacy. However, as I hope to have shown, recent development give us a cause for hope. And hope is sorely needed as the liberal democratic project is under increasing pressure and threat everywhere. And for me, the changing mind and opinion and the hope is an important intellectual characteristic. Why? Here, I quote what Muhammad Hatta speech. Muhammad Hatta is one of the Indonesian founding father. In his book, that the title Tanggung Jawab Moral Kaum Intelligentsia, so the moral accountability or the moral responsibility of the intellectual people. I would say in bahasa Indonesia, orang yang berkarakter tahu menghargai pendapat orang yang berlainan dengan pendapatnya. So according to Hatta, a people who have a character is a people who respect other people's opinion, even though that opinion is a bit different with his own or her own opinion. So that's the character, the people, the character of the people. Ia tak segan mempertahankan pendapatnya sekalipun bertentangan dengan pendapat umum. So the character, intellectual people, he want to defend, to defend his opinion, even though that is not a mainstream opinion. Okay. However, he also brave enough to release his academic opinion if sometimes there are another new opinion, okay, that can be justified by science. So this is what is Muhammad Hatta say. Hanya dengan pendirian yang kritis itu ilmu dapat dimajukan. So only with the critical opinion that the science can be developed. So in this regard, why I'm very happy to read that you explain about your changing of mind. And this is one of the character of the academic, what I call the intellectual people. And now, how's Indonesia? The early period of reform and the reform era paved the way of the increasing role played by the civil society organization in different fields of scope, such as general election, general and specific human rights, environment, political advocacy, education, health, gender, and etc. And the result, this is the result of the several developments, the increasing number of the GSO and their type of engagement, and then type of activity, whether in a policy or social welfare issue, and then also methods of communication, including with the government. Then participation and engagement in the field of government planning and decision-making is more common after the reform era, the beginning of the reform era. But how in the last 10 years? In my opinion, state becomes stronger now. Perhaps not only stronger, but state become too strong. And democratic backsliding began. And this is also evidenced by the increase of the autocratic legalism and also the shrinking democratic space. And civil society currently faces more challenging situation. And actually, the GSO in Indonesia are regulated under law number 17 of 2013 on societal organization. And the law stipulates that the GSO in Indonesia can operate with or without having legal entity. However, in July 2017, the government issued a regulation in lieu of law, or Perpu, which remove a judicial safeguard over the process of banning GSO and other societal organizations if those organizations are considered to pose a threat to Pancasila or the Constitution. And this purpose then was challenged by many GSO and brought before the Constitutional Court. Sadly, however, the Constitutional Court was not in favor of the applicant or the petitioner. And now, what is the challenging and prospect of the GSO in Indonesia? To understand civil society complex relationship to democracy, three features must be addressed or considered. The first one is the political context, and then the second one is the external influence, and the third one is the internal structure of civil society organization. This is three feature or three issue that should be deeply addressed if we want to have a civil society in increasing the quality of democracy in Indonesia. And my concluding remarks that it is important to strengthen in order to face the complex and difficult situation that faced by GSO in Indonesia now. The strengthened networks among civil society element is a must. So what is this element, the possibility of the element, such as the GSO, the academics, and other public human rights and democracy defenders? The second is intensively and extensively disseminate the worst impact of KKN, corruption, kolusi, and nepotism to the people using the familiar language. Because according to the political critical than the political scholar, legal scholar, that the issue of KKN, it seems that that's the elitist issue, and how to make those issues can be understood familiar by the people. And then also keeping an eye as watchdog to all state organs, which play an important role dealing with democracy. The biggest lesson, or not lesson, I think, when the Constitutional Court decision number 19 handed down by the court, then we in Indonesia, mostly the academic, feel that we do not have hope with the Constitutional Court. So it seems that the Constitutional Court suffer from two types of politicization that come from the external politicization, and the second one, this is a more serious one, that the politicization carried out by the internal element. So in other words, the Constitutional Court made what I call as a self-politicization. And it is very dangerous in Indonesia. And then the fourth one is, as I discussed with Mbak Bibip, it is very important from now on to call for international attention to the current process of the upcoming 2024 election in Indonesia. So it is for us, perhaps for us, it is not, so the international attention should begin now, Please do not wait until the each day of the election, that is at February, February 14 February, the Valentine Day. So I think please do not wait until the Valentine Day happen or the general election happen in Indonesia, but please give your attention, critical attention from now on. Thank you very much for your attention. Professor Matthew Harding, I apologize if my reply to you, perhaps to some extent, is not quite true or something like that. Again, thank you very much for your attention.
Thank you, Professor Susi, for a very wonderful response. And we have now around 20-30 minutes to discussion, Q&A. Any question? Okay, 1, 2. Silakan Pak Laude.
Thank you very much. Do I need it?
Yes, of course.
Okay. Thank you very much, Prof. Hardin, for very good presentations on charity and CSO advocacy. It is very interesting and timely, especially for Indonesia, but I think I would like to ask you about, because it reminds me of Australian legal systems, and at the same time, I think it may be also important for us to learn from about judicial activism, because I think this is also related. For example, in the last 50 years of Australian High Court, for example, in my understanding, especially on the issue of environmental law, some of them, they are quite progressive, but to some extent also not. For example, Mabo case also give us a lot of hope. When I tried the High Court decide that particular case, but it's not translated into real policy by the executive and by the governments. So this kind of like difficult to swallow as someone who teaches environmental law. The second, being studying environmental law in Australia and teach environmental law, there are some good decisions at state level. For example, if you are following the decision of Leeds case in Land and Environmental Court, Justice Paul Stein actually at that time introduced the first recognition of precautionary principle in Australia. And now even Justice Brian Preston's been introducing as quite good decision, for example, on in the area of climate litigations. However, with your explanation, because I'm not studying corporate law or charity law, so it is very new for me. As a comparison in Indonesia, most charity organizations actually registered as sometimes foundations, sometimes or that's why I think, thank you for coming back, Pak, because I want to ask you about this also. Yeah, because as someone who actually concentrating in Indonesian's company law, charity organization in Indonesia, I think mostly registered as yayasan, as a foundation, or I don't know, or perkumpulan with this. So I don't know exactly the relationship of the two, whether the status of registration may have a different impact to the role of civil society in advocating change, for example. Many CSO in Indonesia also, just like, what you call it, PSHK, I think it is actually yayasan, right? Yeah. My organization, Kemitraan, also perkumpulan, but that's not impacting the way we work. How it's actually become a problem in Australia, for example, when the court said you cannot include yourself as we cannot recognize you as a charity because, or maybe your registrations are legal foundations, and also the purpose of that. So I find it is a bit concerning. At the same time, judicial activism actually happening, or for example, yeah, a little bit here in Indonesia. But what I want to ask you is that, what is the impact of progressive decision of the court in impacting the lawmaking process within Australia, or impacting the way the government actually works? Thank you so much.
Yeah, I think it's quite a long question. Can you respond to it?
Yeah. Thank you. That's a very, very interesting set of observations. Well, perhaps I'll take first the smaller point that you raised about what impact this law might have on civil society organisations day to day in going about their business. So I'll take Australia because that's the example I know best. Before AidWatch was decided in 2010, this common law rule was applied in Australian law, and it had a very pronounced chilling effect on how civil society organisations went about their business. Note that the rule only ever applied where the dominant purpose of the organisation was advocacy. Most civil society organisations don't have a dominant purpose that is political advocacy. Their dominant purpose is advancement of education or relief of poverty or promotion of human rights or what have you. The advocacy is a means to the end of furthering the purpose. And so it's always been permissible for civil society organisations to advocate as a means to the end of relieving poverty or promoting human rights or what have you. But the effect of the way in which this rule was applied in Australian law was such that organisations self-regulated and withdrew from advocacy, the chilling effect. That was then compounded by the fact that federal governments, particularly in the 1990s and the years leading up to the AidWatch case, really made life difficult for some charities that were perceived to be engaging in advocacy that was unwelcome. And environmental organisations were in the firing line. And that's been a feature of the way that conservative governments have handled environmental organisations, as I'm sure you know very well. But what happened when AidWatch was decided was that the chilling effect just disappeared overnight. That decision coming from the apex court, grounded in the Constitution, then followed up with an act of Parliament to confirm it, was a resounding signal to charities that it's okay to do political advocacy. And it had a very noticeable change in the way that the sector began to operate. So that's just an example, I think, of how the law, both before and then after AidWatch, affected charities on the ground. And then your bigger question about judicial activism, well, there's so many different things that one could say there. I mean, as we know, there are still those in Australia who think that the development of this jurisprudence around the implied freedom of political communication is an instance of judicial activism, judges overreaching, finding things in the Constitution that aren't really there, doing it in spite of what executive government might want to see happen. But I think increasingly that jurisprudence has settled down and is now broadly accepted as a legitimate dimension of our constitutional order. As you say, some judges, even in the High Court, have been much readier to enter into what might be perceived as policy questions and political questions than others have. Some of the more conservative characters have retired and moved on. And so I think the extent to which judges are doing things that some see as activists depends on the composition of the court at any particular point in time. And the only other thing I'd say about the question of judicial activism is that this question comes up in the charity law cases as well, because the public benefit question in these political settings it's a political question, and reasonable people disagree. So Greenpeace in the New Zealand courts at one point was being argued on the basis that Greenpeace's dominant purpose was nuclear disarmament. And there were arguments put to the court that, well, New Zealand, as a matter of public policy, has set its face against anything to do with nuclear. So nuclear disarmament is unequivocally of public benefit in New Zealand. And the court said, no, hang on, we can't say that, because how would we know what the implications for the New Zealand public would be of disarmament around the world? We're not geopolitical experts. We don't know what a nuclear-free world would look like, whether that would be better or worse than the world we live in now. We just don't know. It's not for us to know. So the court there threw its arms up and said, that's a political question, we can't answer it. But then in a case like Family First, the court does answer what seems to me very straightforwardly to be a political question about the role of the traditional family in society. Answers it in a way that was welcomed on the left and not welcomed on the right. So I think you see activism in these cases in the public benefit jurisprudence at times. Yeah, thank you.
You want to add some more, Prof. Susi? Look, okay. Next question, Mas Adil. Silakan.
I'd like to invite a comment from Professor Harding, and also I have a question for Professor Susi. The invitation for comment first. You may have heard, Professor Harding, that recently our apex court, the Constitutional Court, has seen a controversy in that, how do I say this? The Constitutional Court is under fire for a series of decisions, the last of which seems to allow for the form of political family dynasties. And perhaps there is an insight here where we could say that there is a heightened role for CSOs in Indonesia because the court is still because our courts are still in a state where it is still heavily criticized. There is so much room for law reform. I would like to hear if you have any comments on that. For you that there have been issues. Don't think that process change the decision itself.
Thank you. So I'm not an expert on Indonesian law or politics. So I might say two things of a general nature, and then you can take from it what you might want to for your own circumstances in this country. One thing that I would say is that civil society's contribution to liberal democracy is critically important everywhere, that liberal democracy is an aspiration for a people, but it's never going to be sufficient in order for liberal democracy to flourish. You also need robust, functioning, accountable public institutions, state institutions, arms of government, and that has to be working alongside civil society. It's part of the whole. So, in fact, this morning at University of Indonesia, when I was talking to some of the students there, we ended up talking about the United States, which I think is a good example of that general point I'm trying to make. Civil society organizations can do all the wonderful work that they might do to promote liberal democratic values in the United States. But we know that in that country, there's a legislature that cannot get laws made. We know that there's an executive branch that is, at times rotten from the top down. And we know that there's a Supreme Court that is deeply problematic and politicized. And those problems won't be fixed by anything that civil society acting on its own does. Those are problems for state institutions and ultimately the people as electors to resolve one way or another. So that's one general point I would make. The other point I would make is that I suppose what role civil society can most effectively and appropriately play in supporting liberal democracy will, of course, vary according to local conditions. And so what might be appropriate here might look very different from what's appropriate in, say, Canada. And I think that's important to sort of think through and the implications of that. So going to the point about public protest, I think that if democratic institutions are under threat, there, of course, is a point in time at which people need to go to the streets and make their voices heard. That's a very different situation from one in which you have robust liberal democratic public institutions and there are disagreements about specific issues in which we might do better to find a different way of engaging than to take to the streets. So anyway, those are just two general observations.
Thank you.
Yeah. this might be one where you do want to come in, Professor Susi. Please.
Before you comment on that, I also have a further question for Professor Susi. In your opinion, Professor, what do you think there is clarity for CSOs operating in Indonesia, where some may be still operating under the foundation law? They haven't been registered under the new CSO law, compared to those operating under the CSO law, and whether you think this possible gray area will be clarified by the government in the near future or not. Thank you.
Can you repeat again? What is your main question? Whether the CSO operating in Indonesia in current operation?
So how I understand it is that CSOs in Indonesia, there are those that were formed under the foundation law, the yayasan law.
Sorry? Foundation. Oh, yayasan undang-undang.
Yeah, and there are those that have been formed more recently under law number 17 of number 13 of 2007.
Apa?
Undang-undang Ormas.
Ormas.
So we have the yayasan law and the Ormas law, and some are still registered under the yayasan law, and some have moved on to the Ormas law or have been formed under the Ormas law, or both. Yeah. So do you think there is sufficient clarity for CSOs to operate under this system, or if the government should make a more clarified system, and if not, why not? Is there some sort of issue that they are concerned with? Thank you.
Yeah, thank you for your question, and I'm sorry if I give an answer that may not satisfy with your question. But in my opinion, the most important thing is that what kind of policy that should fit with the Indonesian system should be based on what is the main aim of civil society in a democratic country. It is very important because according to law number 17 of 2013 could be registered or not registered as a legal entity. So I think it's depend on the situation, but in my opinion, I think the most important thing is what is the aim. The most important thing is what is the aim of the civil society in a democratic country. Jadi menurut pendapat saya, sistem mana yang paling baik itu harus ditujukan pada bagaimana cara untuk meningkatkan kualitas demokrasi di Indonesia, gitu. Jadi ada mungkin civil society organization yang dia tidak berbentuk pada badan hukum, gitu ya. Tetapi mungkin di dalam kegiatan-kegiatan sehari-harinya justru dia melakukan kegiatan-kegiatan advokasi yang itu bisa meningkatkan kualitas demokrasi. Dan ini menjadi menarik bagi kita. It is very interesting if we learn from the common law system, karena mereka menggunakan charity purposes, ya. Nah, ketika itu menggunakan charity purposes, apakah dia harus terregister as a legal entity? I don't know whether in a common law country, as you mentioned, that civil society and the political who do political advocacy should be registered by the government, or just it is okay not registered by the government, but as long as their constitution, the organization constitution clearly mention the main focus or the main aim of the organization that can be classified as a charitable purposes. Jadi mungkin kita bisa mempelajari itu dari pelajaran. Jadi tapi lagi-lagi gitu ya, kalau charitable purposes nanti ininya apa. Tetapi yang menarik adalah penggunaan benefit public benefit test. Itu yang paling menarik kalau menurut saya gitu ya. Ya mungkin kita juga harus pelajari kan kritik utama dari Perpu mengenai ormas itu, undang-undang ormas itu adalah memberikan proteksi perlindungan yang tidak seperti di undang-undang ormas yang lama. Justru undang-undang ormas yang lama itu mungkin lebih bagus karena apa? Karena bukan contrario actus ya, siapa yang memberikan izin dia yang mengeluarkan, tetapi concern kita adalah ketika berkaitan dengan hak asasi kan, because the right to assembly, the right to have a what is an organization, yeah. So when the government do not satisfied with the activity of such an organization, then it should be better that the government do not have power to directly abolish the organization, but rather, okay, they give a warning or mereka memberikan peringatan 1, peringatan 2, peringatan 3. Tetapi ketika organisasi itu tidak comply, the organization do not comply with the governmental warning, then who should power to abolish that organization should be the court, in my opinion, because it's relating to the human rights. Jadi nggak bisa dengan menggunakan asas contrario actus itu kalau saya tidak sepakat. Siapa yang mengeluarkan izin artinya terus dia bisa membubarkan begitu saja. Nah, kalau seperti itu kan nggak perlu diatur karena pasti sudah dengan sendirinya. Kalau tidak puas dengan pencabutan itu pasti mereka akan pergi ke pengadilan gitu ya. Tapi yang menjadi perhatian kita adalah nggak bisa karena dengan alasan dia mengeluarkan izin karena pemerintah mengeluarkan izin, maka pemerintah yang punya wewenang untuk mencabut. Karena ini berkaitan dengan hak asasi. Haruslah yang mencabut itu adalah pihak ketiga yang netral, yaitu dalam hal ini pengadilan. This is my opinion. Thank you.
Thank you. We have only very limited time today, so I will give chance to Pak Arif, and after that I will invite one question from Zoom. Silakan Pak Arif.
No, Professor already answered that question, but I want to further clarify what the question was. CSO Indonesia is more comfortable using the organization as Yayasan Foundation because the governance is very clear under the law, under the Yayasan law. But then the government asked them to register as an organisasi massa, which is under control of the government. So if there is something that not in the government's eye is acceptable, what their action is, then they can revoke the license. That's why the question is that whether you have to be consistently not applying to register to the organisasi massa and keep working as under the Yayasan law. That's the basically you have already answered that. One question to Professor Harding. This worrying me because we practice law in Indonesia, and how to test the public benefit? Yeah, if here in Indonesia, I'm having client to have some question on the benefit, the benefit, and rely on the court decision, I'll be worried. It is better that because we are civil law countries, participatory countries, it is okay better if we just figure it under the law. I mean, the law clearly define what is the public benefit, or we rely on the court decision.
So that is the most difficult question in the common law of charity. And historically, judges have had to make the decision on the facts of a particular case, is there public benefit here or not? And that has led to a lot of questionable decisions over the years where judges have arguably just applied their own subjective views rather than actually try to arrive at some sort of evidence-based decision. So that's been going on for hundreds of years, and arguably there's an element of that in some of these recent cases from New Zealand, for example, Nowadays, the problem has shifted largely away from the judges and into regulators. So in Australia, charities are registered for legal purposes, and registered charities are then regulated by the Australian Charities and Not-for-Profits Commission, and it's that commission that makes the registration decision. So now you have a government official, and in the first instance, that will usually be a fairly low-ranking government official with very modest resources to support their work, who has to decide whether this organisation generates public benefit or not. And again, how is that person to make a reasoned, defensible decision? The problem is still there. It's now shifted into the regulators. And again, if you look at what has happened in New Zealand in recent years, you've seen regulatory, or you've seen government officials in a regulatory setting making questionable decisions that have then had to be dealt with and solved by the courts. So the problem is there, it continues to be there. There have been efforts over the years to address it by kind of preemptive means. So at times the law has developed to say purposes of a particular type will be presumed to be of public benefit unless there's compelling evidence to the contrary. That has been the historic approach to purposes for the advancement of religion, which are considered charitable in common law. Now, you can imagine how difficult it would be to apply the public benefit test to religion when we're talking about belief and practice. And so instead of requiring decision makers to make the decision there, the law says, no, we will assume that religious purposes benefit the public unless there's some compelling reason not to. So that's one way of dealing with it. But the problem is there, very much so. Mm.
All right.
I just wanted to add a brief comment, which is that I want to go to Robert Hefner's idea of civil and uncivil society. And I think we'd all accept that the state has to retain some power to deal with uncivil society in extreme situations, such as the insurrection in the United States and the Capitol. The problem is how to control and regulate the state's use of that power to ensure that it only uses it to do with extreme cases of uncivil society and doesn't use it against civil society. And the answer really is that the only way to do that is the judiciary. And although the Supreme Court has failed in the United States, the executive at the time under Trump and legislature had failed, the base level courts retained a degree of neutrality. And the insurrectionists were arrested, tried and convicted in some pretty heavy sentences in some cases. So actually the judicial barrier between state and civil society and the proper use of the power against uncivil society ultimately worked at a certain level, even at the top level it failed. So in other words, if the judiciary doesn't work as a sort of defence between, or a shield between state and civil society, you have really grave problems. And Matthew's presentation looked at how the judiciary might deal with civil society and problems when it didn't get it right, and hope when it starts to. And we saw it working to an extent in the US. But if your courts fail, then civil society is deeply exposed to the state, civil and uncivil. And that is a deeply worrying situation. So that was my depressing comment. I'm an agent of depression.
Yeah, I'll give some sample on that issues. For example, if back to the Greenpeace case, if it is a matter of environmental issues, then the judge can rely on the scientific evidence. Might not be 100% true, but at least there's evidence on that, which could be tested scientifically. But another case in Indonesia, how we are dealing with somebody with age requirement to become a vice president, for example. This is good for young people because people under 40, this is they can go to the process of election, and well, against the constitution, of course, but basically good for the people, good for young people. What's the public benefit of that? Yeah. It's debatable. Yeah.
Even in the Greenpeace case, yes, the benefits associated with taking further steps to protect the natural environment because of climate change are incontrovertible. But the test requires that potential detriments and harms to the public also be taken into consideration, and then you weigh them. And so in the case, for example, where Greenpeace's advocacy might lead to a particular extractive industry closing down in a country, you're going to see thousands of jobs lost. A local economy could be destroyed. That's a detriment. Now you have something you have to weigh in the equation alongside promotion of the natural environment, protection of the environment, the sustainability of our future as a species. Now, I think the weighing exercise leads to a fairly clear result in my mind, but the detriment is no less real. And so that too is something that comes up in any case where there are complex consequences of advocacy being carried out. Mm. Right, exactly.
Okay, very lastly, Pak Tim, allow me to invite Professor Sigit Rianto, who is joining us today on Zoom to give some brief comments or questions. Silakan, Prof. Sigit.
Baik, Mas Rizky, thank you very much. Good afternoon, everyone. I'm very sorry could not join directly to the venue due to my tight schedule in Yogyakarta. I think the lecture delivered by Professor Harding today is very interesting and also timely for the Indonesian context. Since starting from this year, so many political events and also so many political discourse going on in the Indonesian political landscape. And there are some points that I think are very important and very interesting from the lecture that has been delivered by both Professor Susi and Professor Harding, namely about the political communication and public interest, as has been mentioned by political Harding in the Australian Constitution, and also in relation with the quality of the democracy in Indonesia. In such a context, then we could have witnessed that the situation in Indonesia is relatively very dilemmatic. When we are discussing the public interest and also public benefit and also political communication, meaning that it is necessitated of public participation in the policy making process. In such a context, then we have a problem in Indonesia in which, due to political culture, transparency, and also political illiteracy among the Indonesia, and on the other hand, civil society has no infrastructure to organize or even to deliver idea of political reform, legal reform to the grassroots. Then it is creating a very difficult situation for the Indonesian political context and legislation, and as well as policy making process. Maybe quote unquote there is political participation. However, this political participation, it seems directed or driven to the procedural formality only in the process. So when we put in the context of the quality of democracy in Indonesia, I am afraid that in the future, our situation is not better, but we should struggle to improve the political and democratic quality in Indonesia. I would like to have the comment either from Professor Susi and also of Professor Harding. Thank you very much, Mas Rizky, for giving me an opportunity to asking questions. Thank you very much again. One again.
Thank you, Professor Sigit.
Okay, thank you, Professor Sigit. Again, that perhaps I could not hear your voice clearly, but I highlight one of your question about that the civil society seems do not have a sufficient infrastructure to increase the quality of democracy in Indonesia. Yes, true that. That's why I mentioned there are three aspects that should be addressed dealing with the complex relation between civil society and democracy. The first one is the political context, and then the second one is the external aspect, and then the third one is the internal aspect of the civil society organization. And this is including the structure, the organizational structure of the civil service. And so to some extent that many civil society organization, and in many respects, that many civil society organizations seems to have an overlap focus on their activities. So I think in the future it is perhaps to it is important to what we call to reconceptualize what is the civil society organization that fit with the need of Indonesian and in the future. So that's my very short answer to your question, Professor Sigit. Thank you.
I'll just add one thing. Again, not being expert in the conditions here that you're looking at with civil society, but one question that forms in my mind is this: where do people come to form their beliefs, their worldviews, their virtues, their habits of mind, all that they bring to their lives as citizens and their contribution to public life? They form all of that in civil society. Yes, in the family as well, but it's through schools, it's through universities, it's through religious organizations, community organizations, clubs and so forth, that people come to have the character and the belief system that they have. And so civil society, one of its most fundamental and most important roles is in helping to inculcate liberal democratic values and virtues in citizens. And that is something that is always worth trying at doing, even if the prevailing conditions otherwise look very dismal. So that's just one observation. Yeah, thank you.
It's time. Dean Harding, Professor Susi, thank you very much. Please give applause both of our speakers. Okay. Thank you once again. I give it back to my colleague Fanny for concluding the lecture. Thank you.
Thank you so much, Bang Gama. Terima kasih banyak, Ibu sekalian. Kita sudah sampai pada akhir kegiatan diskusi internasional pada siang sampai dengan sore hari ini. Sebelum ditutup, saya ingin mengundang Bapak Arief Surowijoyo untuk memberikan token of appreciation kepada para pembicara kita pada hari ini. Kepada Ibu Asfinawati untuk memberikan token of appreciation kepada Profesor Tim. Kepada Pak Arya untuk memberikan token of appreciation kepada Prof. Susi. Baik, dengan demikian kita bisa akhiri International Lecture pada siang sampai dengan sore hari ini. Terima kasih banyak kepada Bapak Ibu para hadirin yang telah hadir secara online maupun offline pada siang hari ini. Sekian, wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh. Thank you.